Today, I'm going to talk about 3 true or false questions. I'm going to give you time to actually give your response in the comments below. True or false? The police did not read me my Miranda rights. As a result, my case is going away. What's the answer? The answer is false. Miranda is only ripe when you're in a custodial interrogation. And what the courts have ruled that you're in custody in a specific set of situations, and that an interrogation generally is a question that is meant to elicit an incriminating response. Technically, custody is hard to define and is relevant to every specific situation in which you're interacting with law enforcement. Now, the courts have interpreted this rule multiple times. So, if you're not in a custodial interrogation, Miranda is not necessary. So if they asked you questions on the side of the road, for example, in a DUI investigation, it may not be in custody, and as a result of that, they don't have to read you Miranda. True or false number 2? My arrest stays on my record even if my case is dismissed. The answer is true. Unfortunately, an arrest is different than a conviction. If you've merely been arrested and not subsequently convicted, the arrest still remains on your record, but no conviction resulted. Often, arrests occur and no cases are subsequently filed. And in that situation, the arrest still exists on your record, and that is a bad thing. What the legislature has done to solve this is they've crafted a remedy here in California to make it so that you can seal and destroy the arrest record if no case was filed and the statute of limitations is passed. If you're in this situation, it is very important that you contact a qualified lawyer as soon as possible, because that arrest alone sometimes can be basis to deny your ability to maintain a job. Contact a qualified attorney if you have questions about a topic relating to whether or not something is on your arrest record. The final true or false question, and the most important: I am always entitled to the use of a public defender as my attorney in court. The answer is false. Each public defender's office has different qualifications to qualify for their services. It often ties to income and assets. And in some situations, you will not know whether or not you qualify for the public defender until at least your first court date. Keep in mind, if you've been arrested for an offense, you should contact a lawyer as soon as possible. Sometimes you can't wait for the first court date, because if you're out of custody and you haven't posted bail and you have a serious offense that you go to court for, that could result in you being remanded. What remanded means is put into custody on the first day in court. If you're concerned about being remanded, for example, contact a qualified attorney. If you have further questions, give us a call at 8336-NO-JAIL.